Okay, we're back, we're live, we're here. It's Wednesday, and therefore, the 1 to 2 block is Life in the Law. Today, we are delighted to have John Edmunds, a litigator par excellence with Edmunds, Verga, and Omanaka, which is in the Davies Building on Bishop Street. It's been there for a long time, and John has been practicing law in this state since 1967. What's your bar number?
734.
Welcome to the show.
Thank you, Jay. I'm embarrassed to admit that I'm that old.
Well, you know, you've seen a lot of things, and you've been remarkably successful as a litigator, and that's why we entitled this episode The Making of a Litigator, because we want to know how you did that. I mean, you've been in Super Lawyers, you've been in Best Lawyers of America, you've represented count them, three governors of this state, one capacity or another, Waihee, Ariyoshi, and Abercrombie. You're in the International Academy of Trial Lawyers, which is very hard to get into. You've been on the Federal Judicial Selection Commission. You've been on the State Judicial Selection Commission as vice chair. You represented one big developer, Chris Hemmeter, for decades. And you've been involved most recently in the Didi case. But you've been involved in so many things, John. It's hard to paint a picture except as a guy who lives and breathes and eats litigation 24/7. Who knows exactly how you see a case, evaluate a case, and proceed to represent your client with vigor. Oh, that's another thing. You have an award that you give at the Bar Association and at the law school for vigorous representation, which is that's appropriate for you as a lawyer who vigorously represents clients. And indeed, a litigator has to do that. You must do that. So tell us about how this migration started from being an ordinary person to a litigator par excellence.
It's a pleasure to be here, Jay. Let me say before I do that, when you talk about this Vigorous Advocacy Award, you left a word out. It's the Edmunds Award for Vigorous Advocacy and Civility.
At the same time.
At the same time, because I am convinced that the very best trial lawyers can exhibit civility,
and they
absolutely need to.
And it's a special brand of human being that can do that, put them together that way.
I also stipulated when I set up the award, which goes to a law student and a member of the bar, that it never be given to me because I'm not sure I meet the civility side of it. But
he's working on that.
The very best lawyers can do that. How did it start?
Tell us when you got off the boat. What did you do? What it was like, and how you migrated in this direction.
I was out here surfing in 1967. God bless my dad came to me and said, you know, you've been in law school, you've been working hard enough. You have friends in Hawaii. Here's a plane ticket. So I went on a fluke that is it would be like bumping into somebody into a supermarket. It led to an interview. I was then hired by what was then the best, if not one of the best, 3 or 4 law firms. Was Robertson, Castle, and Anthony. I know you know about it because your former partner, Ed Bendett, was hired right before I came out. And I came out, met him. In those days, you had to clerk for a year. If you didn't live here and weren't a resident, you had to spend a year in an internship where you couldn't go to court. And that was wonderful training because you had to pick up all the stray dogs and all the cases that any partner in the firm wanted worked on. Terrific training.
That was really an old white shoe for
it was
going
indeed.
Way back.
Yeah. 2 great trial lawyers were there, Tom Waddups and Pete Donahoe, and I worked on their cases, saw them in court, and at the same time, the Vietnam War was really heating up. By mid-69, I was in the firm, I'd passed the bar, but I saw so many abuses of men in the military and men being drafted in who were either conscientious objectors or were drafted in, shouldn't have been drafted in, that I left that firm and opened my own firm mainly to work on anti-Vietnam War cases.
I was going to ask you, that firm, Castle Robertson and Anthony.
Robertson, Castle, and
Robertson,
Anthony.
whatever. You know, nobody's mentioned that name in
forever,
years.
Yeah.
But, you know, that firm didn't do any of these high-profile civil rights kind of issues, military, defense issues. They didn't do any of that.
They didn't then, but they had an interesting history. The senior partner, a man named J. Garner Anthony, who's the man who hired me, and he hired Ed Bendett, had been the Attorney General here during World War II, and he took one of the most famous civil liberties cases ever, where he challenged the existence of martial law in Hawaii. We had martial law here during World War II and for a short time after. And he had been Attorney General, and he challenged the U.S. military in federal court, went all the way to the U.S. Supreme Court and won the case. So they had quite a powerful civil rights background.
Put the firm on the map, for
No
sure.
question, but like many civil rights litigators, he drifted over into more and more conservative clients, Bishop Estate, clients like that. Although, to his credit, at the time of statehood, he went down, I think it was on the legislative floor, and called a number of the sugar factor companies and the people who represented him, quote, a bunch of fascists. And I think he meant it. He was a very, very determined man.
He spoke his mind.
But he had a private...
I remember the telephone number for that firm. Do you remember?
I don't.
I remember it. It was 537-1941.
Ah, very, very interesting.
Not accidental.
Not accidental, I'm sure.
1941 was the year of that big case.
Yeah, that's right, that's right. But he was not too keen on the firm in the 70s taking civil rights cases. And for some reason, I got court appointed into a couple of cases for a couple of hippies that had allegedly had some drugs on them, and the firm wasn't too happy with these folks parading in. But they agreed I could take the cases. I just felt too constrained, so I left on good terms, but I left.
Yeah, but that's so interesting. I mean, you had great credentials. You came from Stanford, right?
Stanford, and then USC Law School.
USC Law School, and you were ready to do anything. You were trained to do anything.
Yeah. And I will say egotistically, I was one of 4 graduates out of 200 that got the Moot Court Honors Award from court competition. So I knew that's what I wanted to do.
Yeah.
I wanted to get into court.
And you wanted to be, you were prepared to be a litigator. Okay, so now this was in the day when there was plenty of activism going on, plenty of great issues going on. It was Vietnam. I mean, everybody was upset about everything.
Well, it was Vietnam, and it was possession of 1 marijuana cigarette was a felony time. 1 cigarette, even in a group, if you passing and smoking 1 joint, convict everybody for a felony.
Wow.
So we brought a lot of motions to suppress the evidence. Yeah. I had my own firm for about 1.5 years, was getting into all these cases, and then Brooke Hart, whom we all know, was appointed Chief Deputy Public Defender, and he had seen me argue a big conscientious objector case.
You didn't know him otherwise.
I'd met him. He was a good, he was a good friend of Ed's.
Yes, right.
And I'd met him.
Talking about Ed Bendett, who was my
former partner,
who was in the middle of all this somehow.
More than you know. I'll tell you a good civil rights story about Ed, who worked with Brooke and me on a significant case later. But Brooke called me. He'd seen me argue a case and called and asked me to come over as Chief Deputy. 2.5 years out of law school, you have your own secretary, pick the cases, you can try them, you take them on appeal, you have a research assistant. That may not sound like much now, but that's big stuff in those days. So I did that, and I was there for 2 years and tried everything, just tried it all. And
That changed you. That changed you.
Indeed. Yeah, that's when I started to see things like young local kids arrested, and on the way to the station house, they'd stop and take them out and beat the bejesus out of them. Local cops beating up on local kids. Not every time, but enough. I'd never seen anything like that. I mean, I was a nice middle-class kid from Southern California. Just never seen anything like that. I'd read about it, but I'd never seen it. Until you got something like that in your office, you don't become a believer. And so I would defend those cases. I would bring civil actions against the police because of that.
Criminal actions.
Well, civil, and file a complaint with the police.
Yeah.
But it's hard to complain to the police about what the police did. They didn't like that too much. Went into federal court over that a lot. Had some success. In fact, later on, when Governor Aishi asked me to represent him, he was sued in the Hal Hansen case, where the star witness sued him. And I remember over Kukui Plaza, and the Attorney General, Ron Amamiya, called me up and he said bluntly, you know, you've been kicking our butt in federal court in these same kinds of cases. We'd like you to step in and defend us.
Small town.
Yeah, and I did successfully. But those kinds of things feed one on the other. That, in the old days, is how people learned who the really great or good trial lawyers were. You would either go down and see them, or you'd read about it. Not as much anymore. It's not as well publicized as it used to be.
Well, let's talk about how it was in terms of the practice. I mean, a lot of people who've sat at this table in life, in the law, and in our bar association program, you know, talk about the difference between civility and the daily practice then and now. You know, the handshake deals, the relationships, and some of them have been on one side of that coin, and others have been on the other side. They're not all in the same place on it.
No, that's right.
How was it in your perception?
There were two sides to the coin. I remember vividly, there were prosecutors that would be prosecuting a case I had, and you could do a handshake. Lloyd Ching is now retired, it comes to mind. You could do a handshake, you could go into court and try to beat each other's brains out, go out and have a beer afterward. Those days are gone. They're just sadly gone. There are other honorable prosecutors now you can do that with, but it's not as casual as it was. Also, though, it's not nearly as complicated. You could go to trial in a case where you get out of the courthouse and you might have 5 documents in your file.
Yeah.
There's no such case anymore, civil or criminal.
Why is that?
As great as the data processing revolution is, this is just Edmunds on data processing, okay? I know you've got a different view. And I love it. We all love it. It is a tool that enables the small civil firms to fight against the biggest. But at the same time, it enables the creation of endless paperwork. There are forms for everything you do that you copy out of a prior case or somebody else has used. You want to use it, you want to annotate it. There's a long series of articles about how the opinions being written by judges, especially federal trial judges, are too long. They're endlessly footnoted. And the footnotes are footnoted because there's this incredible backlog of material on which to draw and which can easily be cut and pasted into an opinion.
On both sides.
On both sides. Contrast that with a speech that the Chief Judge of the Ninth Circuit gave at a seminar I was at, I don't know, 10 years ago. He used to hand write out his decisions, every word. Chief Judge, Ninth Circuit. Nobody has time to do that anymore. And that's just gone the way of the dodo. It's good, it's bad, but it is creating an enormous volume of data, paperwork, and very complicated cases. Now, does that translate into more or less civility? I don't think it does directly. I think what it translates into is more complexity, more openings that people perceive they can try to use to take advantage, generating more paperwork, more deadlines, more missed deadlines.
More expense.
Well, to say nothing of the expense, yeah.
Yeah. I just wonder, you know, part of that whole scenario is, does it give you better justice?
I think it gives you uneven justice. And this is a point on which I'm very conflicted. On the criminal side, of course, you've got to go to trial. There's no alternative dispute resolution. But on the civil side, there is what's called alternative dispute resolution, where a judge has the power, and they all use it, to send a case over to a private mediator to see if it can't be worked out there. That sounds terrific. But when you go, you got to pay, most of the time, you got to pay the mediator. The good mediators have to be paid. That means each side in the case has got to pay. You can, if your client can't afford it, they send you to a different court-appointed mediator. But that takes time. It takes the lawyer's time. I am mainly a plaintiff's lawyer on the civil side, mainly a plaintiff's contingent fee lawyer, mainly a plaintiff's contingent fee lawyer in very big cases, medical malpractice, serious personal injury. But every new layer one adds into the process is time, and time, as far as I'm concerned, is expense. The defense lawyers love it. They bill by the hour. But that back and forthing to a mediator, back to court, I'm in a case now, it's going to a second mediator, back to court. Every time you add a layer, you add time and expense. It drives up insurance rates to defend because they got to pay their lawyers. It drives up what plaintiffs try to recover because we've got to try to make the case worthwhile. And it also takes a lot of the litigation out of the public eye because all this mediation, as good as it can be and as bad as it can be, it's all done privately, it's all confidential. It used to be you could go down there to the courthouse. Let me take you back to a time before my time, a time when, before TV coverage in the courtroom, before the press could be in the courtroom, you'd go down and you'd see lawyers in action. You'd go down there. Well, there's no there anymore. You know, there is no arena in which one can go down and see all the trial lawyers in the bar on a given day. It used to be on motions calendar, you know this, in the 60s and 70s. There was a day in the civil court on a Monday when Judge Fukushima typically would hear every motion in every case. You'd go down there at 9 o'clock. Every lawyer with a pending case that had anything related to it would be there.
And you learned a lot.
Well, you learned a lot and you got your head handed to you
That
or
too.
you got praised. And similarly, on the criminal side, every Friday, Judge Alan Hawkins presided over 80 or 90 people, lawyers, with their clients there and the prosecutors on hand for every indicted case. Yeah. And you saw who was who and what was what. Now, you didn't try those cases, but people got to know each other. It was harder if you were prosecuting and I was defending and we were both there on a case. It was just psychologically harder for you to try, not that you do it, but for you to try to pull a fast one 3 days later. You know, there was a there and people came to know and respect each other. that's all gone. Is it better or worse? It's the way it is, and you try to adapt, but it's gotten, in my view, too time-consuming and too expensive. It is getting out of control.
I want to talk more about that after the break. There was a there, with John Edmunds, a super lawyer, a super litigator. We're examining his trajectory here, and it's really interesting here on Life in the Law, The Making of a Litigator. We'll be right back.
Inspired by an ancient culture, classical Chinese dance, vigorous physicality, timeless stories, 5,000 years of Chinese music and dance. Shen Yun presents authentic Chinese culture. Coming to Blaisdell Concert Hall, May 8th and 9th. Tickets at shenyun.com or call 808-792-3919.
Hi, I'm your host on ThinkTech Asia, Bill Sharp. I look forward to you joining us each Monday between 4 and 5 o'clock when we film right here in our studio in downtown Honolulu. The show, ThinkTech Asia, focuses on contemporary events in Asia. And by Asia, we mean anything from Hawaii, south to Australia and New Zealand, west to Pakistan, and as far north as the Russian Far East. Clearly, this is one of the most economically dynamic centers of the world, and we bring you up to date on what's going on in a whole host of countries in this very vital region. We look forward to seeing you. Aloha.
Okay, we're back. We're live. I'm Jay Fidel here on ThinkTech, Life in the Law. On Wednesdays, we have John Edmunds, a super lawyer, super litigator with us. And we're talking about the making of a litigator, which is really an important process, and we need to know about it, not only historically, but now, too. So this was where there was there, and you could see it, and there was a certain transparency. And when it allowed the public to come into the courthouse, the public could really see something, get their hands on it. And there were people who were like professional spectators who would come in and sit in the back of the courtroom and they'd see it happen.
See these guys every week.
You were talking about one during the break?
Well, this fellow was quasi-professional spectator and lawyer, a fellow named Monroe Matsumura. Old, I don't know, he must have been 75, 80 years old back then. And he had an amazing voice. He had one of these, they call it back of the bowling alley, booming voices. And when he would stand up to just announce to the court that his client was there, this guy had a presence about him. I mean, I think I'm pretty damn good, but I've never been able to do what he could do with that voice. Yeah. But a number of articles have been written over the years about how there really was a there. Jerry Spence, who, by the way, was a client of mine, I have to tell you. Yeah, I represented Jerry.
Name,
yeah, but he's a magnificent trial lawyer out of Wyoming. Represented Kimberly Pring in the Penthouse case, represented Imelda Marcos. But he tells a story about how when he was cutting his teeth in Riverton, Wyoming, in the winter, and they didn't have video, and they didn't have TV, and it was snowing, and so the farmers couldn't be out in the field. The only entertainment in town was to go down to the courthouse. And the judges would let him go because if they shut down the trial early, everybody had to go home and sit by the fire. And what a magnificent crucible in which to train. Now the premium is on getting into court, getting it over with quickly, getting out. I have a colleague who was here. He started here. He went up to Stanford, became chief counsel for Stanford University. He was saying to me, you know, John, it's great that you all do trials, and it's interesting work. But he said, we're going to have algorithms for all that pretty soon. Algorithms.
I've heard that
feed
said,
the data
John.
in. I hadn't. It just shocked me. We feed the data in. We get the result out. And Jay, as great a guy as this guy is, we've got a thing called the right to a jury trial, and it's
That's
being
not going away anytime soon.
Well, you hope not, but it's being whittled away at. It really is.
Yeah. Well, you can see one day you put all the data in, the thing goes through its algorithm and it spits out a verdict, and that's that.
But when that is life in prison or all your property.
Yeah.
I don't
if it's wrong, you're in
if it's wrong,
deep
you're in deep
kimchi.
kimchi. Yeah. And the problem is because everything has sped up at such an enormous rate, thanks to the data processing revolution, a lot of pluses to it, but people expect results faster. They don't want to sit there through a jury trial. There's one reported case where a guy in Oklahoma on a jury raised his hand. He said, Judge, shouldn't this have been settled in mediation? Well, why are we here? Well, there's a hell of a reason why we're here. It's called the right to a jury trial. But when the public's attitude starts changing, that becomes very dangerous.
Well, you know, you talk about the classical days, and I really think there was a golden day there in the 60s. I remember Melvin Belli in San Francisco, Hyman Greenstein here.
One of my clients.
Is that right?
Yeah, I defended him.
He was really an incredible
Successfully
guy.
defended.
With a white suit and a green shirt and everything green.
Yeah.
Drove a green car. But you know, in those days, the lawyers got up and they made impassioned, super articulate pleas. They spoke from the heart. They spoke truth. They were very powerful personalities, litigator personalities like you. And they made their case, and the judge sat and he made a decision based on, you know, what they presented to him, and it was over very quickly. And it was right. It was right because it was
Most of the time.
Most of the time, not all the time. A crucible was happening. And it was a depoliticized kind of crucible. It was the pureness of that argument in court. When you add all those layers of process you were talking about, you know, it should give us some concern, because it does tend to, what did you say, the justice now is uneven?
I think it's uneven.
What does that mean?
I think it always has been. I think people who can hire good lawyers in criminal and civil cases do better than people who can't. That's why the contingent fee exists in this country. It's been called the poor man's key to the courthouse door. Literally, I could not afford to hire myself on an hourly basis if I had a major automobile accident where I had to bring a case. So the law lets plaintiffs' lawyers take cases on contingency, meaning we take a percentage of the recovery if there is one. Between the beginning and the end, we've got to put up the costs. We have to put the costs into a case. Costs now for a simple, basic rear-end collision case, take it through a jury trial, probably $50,000 to $60,000 for a week and a half.
Whoa.
And
you could make it more if you want. It could be more.
Well, if the defense tries to run it up, which they often do.
Yeah.
Jerry Spence has this great retort to defense lawyers. He says, you guys are like the torturers during the Spanish Inquisition. And he pulls out the books that show the torturers in the Spanish Inquisition got paid by the hour. So they made it last longer. Quite literally, it's horrible. But sometimes it's true. And those guys on that side think they're doing the Lord's work. They think they're standing between runaway justice and a huge plaintiff's verdict and their doctor, their hospital, their truck company, whatever it is. And you know, I don't try to take those sides. I mean, I have both defended and I've sued on behalf of. My sympathies are with the injured plaintiff, with the criminal defendant who's got to stand up against the investigative and indicting powers of the state.
The system.
The system.
And the insurance company system, which is formidable.
Yeah, absolutely. But in the back and forthing, you hope that what comes out of it is justice. As you make it more expensive, as you make it take longer, which is what we're doing, which is a paradox given the data processing revolution, who suffers the most? The victims. Yeah. The little guy suffers more than the big guy.
So you're talking like a plaintiff's lawyer now, but,
yes.
But from the time of all that controversy in the 60s until now, you have engaged in so many different kinds of high-profile cases. I mean, if it's high-profile, if it's major controversy, you've been involved. You're in the history book of Hawaii in every single one of those cases. And that's more than just plaintiff's personal injury. It's more than just insurance, criminal defense. It's the whole enchilada. How do you do that, John? I mean, how do you handle so many different kinds of specialties all within this bundle of litigation?
I've had great partners. You know that any good to great trial lawyer, if he's going to be out there, has got to have people behind him. I had a partner for years who had to retire recently due to health, Ron Verga, who did all the research. I have another partner who is my second chair when we get into a courtroom. We've deliberately kept our firm small. The other way you do it is I will often be brought in by a firm to try the case for them, so you have help from them.
They work it up.
Yeah.
And then
they work up some of it. You can't let them work it all up, because whatever it is that people think I can contribute, I need to see it develop. Yeah. But if what you're also asking is how do you get those cases? What makes them come in? I had a very strong axiom when I left the Anthony firm, and that was any client came in, if they were high profile, if they were a politician, it was Chris Emmett or whoever, I would say to them in the beginning, I want to be clear about something. I will take your case, but if I take something else, if it's a controversial murder case or a controversial assault case, I don't want you calling me and saying, hey, what about this? Because it's not going to cut it. I'm going to take the cases I want. And I'd be polite, but I'd say, if that's a problem for you,
tell me now.
Tell me now. And you know, to a person, what they all said was, and I can hear what the senior partner's answer, well, you never would say that, was always, thank you, I respect that, you're exactly the kind of guy I wanted to hire. I had a very famous, infamous murder case I defended, the Toledo alleged murder. She was acquitted, although it was a battered spouse case. But during that time, I was doing some very highly publicized business work for Chris Hemmeter. And we were joking one time, and I said, you remember what I told you about? And he said, oh, I'm not only, it doesn't bother me that you're in there. He said, could you get a jacket with my name on the back when you're in the courtroom? Also the attorney for Chris Hemmeter. So, but I think, I think the attitude changed too. When I came out of law school, the big law firms, as you put it, the white shoe firms, in most cities had captive clients. For whatever reason, it was both a change in the times, and I think Honolulu was different. When I first met Chris Hemmeter, in San Francisco, Los Angeles, Chicago, New York, a client like that would probably never have been introduced to me. A big firm that had him at the time would have kept him. They would have not locked him up, but they just would have done things such that he never would have met a guy like me. His partner was also a partner in the big firm that brought me in, and he didn't share that view. A wonderful guy named Henry Shigekane, you remember?
I remember.
And in Honolulu at that time, it was true of the way your firm formed, business clients were willing to look for talent. And if they thought your firm had a J. Fidel or an Ed Bendet, they didn't care that you were a small firm. And that was a tectonic shift in the law business, talking about not the plaintiff side, not the criminal side, but the business side. And that shifted radically, I think, starting at about 1970 up through the 80s and 90s. And it's very true today.
There was another shift too, though, and that was the shift that local firms were being cut out of deals that involved national firms on the mainland. They were effectively practicing here, and local business lawyers didn't have as much of that work, and still today they don't. The other thing is that I think somewhere in there, and this goes directly to your career, lawyers became commodities. They became fungible. So in a business setting, you go to one guy and say, what is your rate?
Yeah.
And you would give him the rate, and then he would go to the next guy in another firm, and he's, what is your rate? And there was a $5 difference, and he would take the cheaper rate. Yeah. And it had nothing to do with the process you just mentioned about how they would go to somebody they really liked, somebody with a chutzpah, somebody who had a little sass, who was not afraid, and courage in the courtroom kind of thing. And I think that's where we are now, actually. It's the rate that counts, and in many ways, the lawyers are commodities, except in large litigation like what you do.
Yeah,
that has retained the personality thing.
I think that's true, sadly, but it has become more and more of a business, less and less of a profession, especially in what you're talking about, the transactional area, something that never is destined to go to court. Sometimes it does, but it's not designed to. There'll be a merger, an acquisition, an enormous lease rewrite, and it's never designed to see the courtroom. And the law firm that gets hired is often the one that will quote the lowest rate, not the one that often winds up sending the lowest bill, but they'll quote the lowest rate.
There's no qualitative analysis at all.
Not much.
And there could be, in a business deal, there could be just get me through the deal, or get me a deal that's best. Get me a deal where I save $1 million, okay? And we still take the rate that's $5 less.
The other thing that's happened is lawyers get sued more and more. It used to be that if a lawyer made a mistake, he'd get sued, and he should be sued. Then it got to be, if it was borderline, he'd get sued where he hadn't been sued before. And then it became, and this isn't just me, this is senior partners in LA, New York, San Francisco, guys that I talk to a fair amount. You can do a perfect job. If the deal goes south, they will line up everybody in sight. You can do a perfect job for a client. If the client dies, a very wealthy, elderly client, his personal representative, his estate will come in and pick over everything that happened.
And he's not somebody you know. You have no relationship
with him.
Not
at all. And then they'll
say, it's not like he cares or appreciates you.
Mm-hmm.
Yeah. Well, I mean, this is a change in the way the law has been practiced in Hawaii and other states in this country. And some of these changes are really not terribly attractive to a young fellow or girl who wants to go into practicing law, and the dynamic, the opportunities, the attitudes have changed, and I would like to talk to you about that after this break.
All right.
I would also like to talk to you about lawyers who have done things other than practice law, such as, for example, consulted on the making of Hollywood movies, John.
Okay.
When we come back, we're going to find
I
out
thought you
about
meant
it.
your TV program.
Well, maybe in a way I do, but primarily, John has consulted on a number of movies in Hollywood, and it's really wonderful. John Edmunds, super litigator, and here, the making of a litigator on life and the law. We'll be right back.
Hi, I'm Ethan Allen. I host Likeable Science on ThinkTech Hawaii, and I do this because I care about science literacy in Hawaii. I want to spread the understanding that science is a vital and interesting part of everyone's life. I want to make sure the broadest possible spectrum of people understand the beauty and the value of science and realize that science plays out each and every day of their lives. I want you to understand that science is fun. So we bring on to this show each week guests who are scientists, from astronomers to zoologists, and we talk about what they do and how they do it. But most importantly, we talk about why you should care about their work, why you should see that their work has value and impact on your life. So I hope you'll join us Fridays, 1 p.m. here on ThinkTech Hawaii. You can watch us via live stream. You can watch us recorded on Toledo, and you can see us each week. We hope you'll join us.
Okay, we're back. We're live. I'm Jay Fidel with John Edmunds, my friend for 40 years.
Or at least 40.
At least 40. On Bishop Street. We've watched Bishop Street come and go all these years. And we're talking about, a super litigator here and the making of a super litigator here on Life and the Law. So before we go on to the question of what lawyers do in their spare time, let's go back for a minute to the Toledo, the Gertrude Toledo case you mentioned, because that was really high profile. She was in a wheelchair, as I remember. She was on the front page every day. It was a murder that was out in
An alleged murder.
Alleged,
For which she was never convicted.
It was a dairy was at stake, a little family dispute, so to speak. So what happened there?
Gertrude Toledo had been quite a celebrity here in her much younger life. She had been the opening act for the Harlem Globetrotters. She was the girlfriend of Abe Saperstein, who founded and created the Harlem Globetrotters, and he took her with him on tour. There were pictures of her. She was a truly beautiful woman. Dancing the hula in Stockholm, Sweden, in the winter before the opening playoff with the Harlem Globetrotters. I mean, she'd be on the basketball court and the snow is falling outside. She'd come on in a grass skirt. She fell onto worse times. She had a stroke. She married a man named Robert Toledo. They had a good marriage for a while. It soured. They owned a large dairy out in Waianae. It turned into a battered wife case. And I didn't know it when I got hired, but she had picked up a gun, shot and killed him. And that was on the front page of the paper when I drove into my office that day and got a call from Walter Chuck, who'd been her lawyer. You talk about a super litigator.
Yeah.
Walter is gone now, but he was the great trial lawyer of his day. And he'd been her lawyer, but he was not able to take the case. He had represented the husband on a matter as well. So he asked me if I would take the case, and I did. It was a year and a half out of my life, which I spent willingly, but I came to learn that there were hospital records of him having beaten her, and that she had been a battered spouse. They had the resources to hire one of the best experts in the country on battered women, a woman named Lenore Walker, who wrote a book called The Battered Woman. At that time, she had worked with more case histories of battered women than anyone in the world. And she was a PhD in sociology, incredibly brilliant. She'd come up with this theory called learned helplessness. Why is it women don't get up and leave when they're being battered? And that's a long story, but there's a real good reason why they don't. And she was able to come into court and testify that Ms. Toledo, Cappy Toledo was her nickname, had been a battered spouse. Now, this is a tough sell when your client picked up the gun and pulled the trigger and shot the guy. I'm laughing, but
she was in a wheelchair at the time.
Well, she was and she wasn't. She was a stroke victim and was on a blood thinner. There were times when she'd have to be in a wheelchair, times when she would not. By the time of the trial, we had a doctor say she needed to be in a wheelchair, so we had her in a wheelchair. We had a nurse in attendance, but there was no question that it was a valid condition, and he knew it. So with the evidence from Lenore Walker And to the state's credit, they brought down their own expert to say she wasn't a battered woman, and that's what trials get to be all about. 6 weeks to a verdict, and the verdict was not guilty.
Whoa.
And that was, Dan Rather sent a crew down to cover the verdict.
Wow.
It became high profile, not just because of who she was. I want to talk about that in a second, but it also became high profile because it was the first time in the history of the state of Hawaii that the issue of a battered woman defense came up, and it was the first time necessarily that a judge allowed those instructions. Some judges around the country would not permit the defense.
So cutting edge.
Cutting edge with the weight of Lenore Walker's testimony, who went on, by the way, to be a star witness in the O.J. Simpson trial. Never had to testify, but the weight of that ruling by the judge, Judge Robert Klein, later on the Supreme Court, now retired, very powerful. But afterward, I talked to the jury, and it was a cliffhanger. It was a real cliffhanger of a case. But that was
Well, for the
6
litigators,
months,
especially
a year out of my life to get it ready, and 6 months to try it.
I'm sure you loved it, though. I mean, as a litigator, this is really exciting. The stakes are so high, and the creative possibilities are huge, and you played them out. Yeah.
And you never know what's going to derail
No.
a jury. Just quick example. We had a recorded statement. She'd given a statement to the police. They'd taped it. We'd had it retaped twice in the reproduction, and we needed to play it for the jury. You can't talk to a jury during a trial, obviously, but afterward, with the judge's permission, you can. So after the verdict came in and talked to them, one of the things that hung them up was we had used a 3rd or 4th generation version of the recording. And they thought we had tried to make her seem slower in the use of her speech. Never occurred to anybody.
No.
And it's a good lesson. I'd learned it in other cases, but you never know. Juries can take off on anything.
Yeah.
Another thing that came out, we spent a lot of time questioning the jury about, especially the women, about whether they themselves had ever been victims of being abused. Because you don't want abused women on the jury because they think, some of them think it's okay under this theory of learned helplessness. But you want to find out. In talking to the jury afterward, a couple of them told me they weren't honest in answering the questions. You don't come out and say to me, your husband ever beat you up. Yeah, voir dire, when you get to question the jury.
Yeah.
You don't say, does your husband ever beat you? What you start in with is, have you ever had to sit with a friend who may have been abused by her husband and, work into it. But one woman who absolutely said, no, it never happened, came to me later and said, yeah, my husband had beaten me, but only when I had it coming. And
What?
Yeah. That was not the way I was raised.
Whoa.
That entire case and the whole notion of battered and abused women was absolutely outside anything I'd ever heard of or seen growing up. It just was out of my world.
Cut some new turf
Yeah.
on that for sure.
But
What year was that, John?
That was 1985.
So somewhere in there, you decided to get into the movies.
No.
And it lays a whole new, aspect, because now you're doing these super cases, litigating a storm everywhere, and now you're consulting with Hollywood on how to make movies about super litigation cases.
Well, not quite. I like to say the movies got into me. I was asked to come in, but
okay,
you want a
whatever.
quick version of that?
Okay, all right. So tell us the story.
I have a cousin, Robert Towne, who's a very famous screenwriter. He wrote Chinatown, won the Oscar for it. We were very close. We grew up together. I'm down in Oklahoma trying a major case, and it's 4 in the morning, and the phone rings, and he knows how to find me. And I hadn't talked to him for about a year. Short conversation. I've been hired to write the screenplay for The Firm.
The Firm with
The Firm.
The Cruise.
Tom Cruise.
Yeah.
And I know you were in a big law firm, Robertson, Castle and Anthony. He knew that. I had done some legal work for him. He said, would you be willing to consult? And I go, well, yeah, you got my attention. And I said I would. He said, what I'd like you to do is vet the screenplay for dialogue. Is this the way people talk to each other in a big law firm? And of course, Sidney Pollack, who was one of the great directors of all time, who became a good friend, but he was the director, and he too, they asked if I would do that. So I got in, started reading the script, and commenting on the dialogue, and it needed some, but what really struck me, and this takes nothing away from the story, but the ending was not one that I thought was a good one. In the book by John Grisham, although it's a great tale, the lawyer becomes corrupt. He takes all the money that the mob has put with the firm to steal from whomever, and he takes it all and he runs off to the Caribbean with his wife. And number one, I know enough about organized crime to know you don't take all the mob's money
And
and
get
go
away
into
with
the
it.
Caribbean.
They can find you too
Well,
quick.
they find you, and they have what euphemistically we could call their own form of final and binding arbitration. It's very final and very binding. And I told Bob Town and Sidney Pollack that, and they said, well, can you come up with something better? Can you come up with a different ending? And I said, well, can I have a week? And I came up with a week. And so the ending got changed. And the ending was that Cruz did not steal all the FBI and reward money. What he did was he turned the firm in. He turned on his own firm. And there's a line in the movie where Tom Cruise is meeting with a client. He happens to be black, Afro-American, and a businessman. And they've sent a bill, and the client's complaining about the bill. And the client says, you know, I don't mind a little overbilling, but there's too much here. And every time you put a bill in the mail, and then Cruz finishes the line, he says, and put a postage stamp on it and drop it in the mailbox, it's mail fraud. And so that was my contribution to this whole thing, and they liked it and they changed it. From that, Sidney Pollack asked me to work with him on another movie that he was to direct called Recount, which was the story of the Bush election, Bush-Gore election.
The hanging
The
chads
whole-
and all
yeah,
that.
the whole catastrophe. Tragically, after a dinner at which he had asked me to do that and spending some time with him, and it's very bittersweet, I still have the emails from him, he contracted pancreatic cancer and died. And it happened over a very short period of time, and he was gone. And obviously somebody else came in whom I didn't know, and it took it over. I understand that.
Yeah.
But it was a real tragedy obviously for him and his wife. But for me, it was just so sad to have touched somebody that great and had the chance to work with him. And then
Too bad.
it fall
But
apart.
at least you had the opportunity anyway. Now, that was a great part of your career to,
It was
to
exciting. It was
share
very
the
exciting.
lessons of the practice, you know, with everyone in the public.
But there's a lot they don't want to hear. One thing about a screenplay is if you made a story about lawyers, really a story about lawyers, probably nobody'd go, or if they were in the theater, they get up and walk out, because it gets very boring.
It has to be dramatized.
It has to move,
Yeah.
and I learned that.
So, but the career continues throughout this. That's just a hobby, although I'm sure you put plenty of time into it. How did the kinds of cases you were working on, how did they evolve? I mean, there was probably a sea change of some kind, from, you know, a mix of this kind of case to a mix of that kind of case. And, you know, now, what's your favorite kind of case that you're doing now? Where's your head at in terms of, you know, doing the best you can for the clients you like?
My favorites now are the major criminal cases. I don't do very many. I'm not a fan of routine drug cases. Drug defendants have a right to be defended. I don't want to spend my time there. But I do handle major criminal defense, white collar and non-white collar, and major plaintiff's personal injury, major medical malpractice. And that's where I'm now putting my time.
It's interesting.
Still,
So this is where you
that's where
wound
I
up, so to speak.
Wound
in your
up and
career.
want to be.
Yeah.
Over the years, you know, I don't cross-examine my clients about why they walked into my office. A lot of business clients come in because they've seen something you've done. I've had clients that I've sued come to me afterward and say, you know, next time through, I want you on my side of this. I don't want to go through it again.
Small town.
It's true, but you know, that's true in a lot of cities. I'd heard that when I was in law school. I didn't believe it. It happens.
Okay, one last question.
Sure.
We only have a few seconds left.
All you want.
What's your advice? Turn to the red light out there and tell those young people your advice on how they can conduct a career in litigation.
If you want to be a trial lawyer, and many of you may not want to be trial lawyers, I understand that, get a job in the public defender's office, the prosecutor's office, the attorney general's office, in the trial department. And if you can't do any of those things, go to some firm and offer to work, maybe for free. There's a legendary lawyer in San Francisco, he's gone now, who started out, he went to all the firms that had anything to do with personal injury cases and said, anything you don't want, anything you think is a dog case, it won't succeed, give it to me and I'll do it. His name was Bruce Walkup, and he wound up probably at the top of the heap of the plaintiff's lawyers there. So if that's what you want, that's how you go get it.
And you had to feel it in your belly, too. John Edmunds, who's been feeling it in his belly now since 1967.
So much it hurts.
The making of a great litigator here in Life and the Law. Thanks for watching. Thank you for John.
Jay, thank you. That was great.
Aloha.
Thank you.